Great. Well, thank you, Maya, and good morning, everyone. My name is Marty Rabinovitch, and my topic this morning is employment law in Canada. So we are going to be shifting gears a little bit again. So you've heard a lot about bringing employees into Canada this morning, and now I'm going to speak a little bit about some important employment laws for employers to be aware of. So we'll start with wrongful dismissal law. And I'll just start by saying that the laws that govern wrongful dismissals in Canada are very, very different from what the norm is in the United States. So if you're an American employer and you're looking to set up shop in Canada, this is different and it's very important. So the main purpose of wrongful dismissal law is to protect employees and essentially to ensure that an employee who loses their job through no fault of their own is entitled to a salary for the period that they will need to find a new job. Now, if an employee has been terminated for just cause or a valid legal reason, then they will not be entitled to any severance package. And examples of behavior which may amount to just cause include theft, insubordination, dishonesty, bullying or harassing your coworkers, and the list can go on. If the employee has been terminated without cause, so if there was no valid legal reason to end the employment relationship, then the employee will be entitled to a severance package. So certain situations which would result in a termination without cause are things like restructuring, insufficient work, if we have an employee who is simply not getting along with their coworkers, and again, the list will go on. At common law, so in the world of the court decisions, there is a very, very high threshold for an employer to meet in order to establish that an employee has been terminated for just cause. So at common law, to constitute cause for dismissal, the employee's misconduct must be sufficiently serious that it strikes at the heart of the employment relationship. So the court will consider whether, in light of all the circumstances, the employee's wrongdoing is reconcilable with sustaining the employment relationship. And when we're dealing with cases involving employee dishonesty, the test will be whether the employee's dishonesty gave rise to a breakdown in the employment relationship. So in other words, the punishment has to fit the crime. If you have an employee who has engaged in some sort of misconduct, then probably they deserve to be punished, and the employer will be justified in disciplining them, but a termination for just cause may not be warranted. And when we're dealing with terminations for just cause in the legislation, the test is a little bit different. So if we look at the Ontario Employment Standards Act, we see that employers don't have to provide notice or severance pay if the employee has been guilty of willful misconduct, disobedience, or willful neglect of duty that is not trivial and has not been condoned by the employer. So arguably this test is actually an even higher threshold for an employer to meet than the one in common law. And similarly, if you have an employee who has applied for unemployment insurance benefits after their termination, and Service Canada, so the Canadian government, determines that the employee lost their job because of their own misconduct, then that employee will not be eligible for EI benefits. So how do we determine the severance package in cases where an employee has been terminated without cause? There are three places that we have to look. The first is employment standards legislation in Ontario. That's the Employment Standards Act 2000. In other Canadian provinces, there will be a different relevant statute. We also have to look at the employee's employment contract, so specifically whether there is a termination clause which would set out the employee's entitlement upon termination, or maybe even limit that entitlement to simply what is contained in the Employment Standards Act. And then we also have to consider the common law, which again is court decisions. The entitlements that are set out in the ESA are an employee's minimum entitlements. So an employee and an employer are not permitted to contract out of those entitlements, and any attempt to do so will not be enforced by a court. And it's possible for an employer to have a termination clause which either limits an employee's entitlement to the minimum set out in the Employment Standards Act, or a termination clause might also set out an entitlement that is greater than the ESA entitlements, but less than what the common law entitlement might be. So there is some flexibility there. And as a quick note, the Employment Standards Act only applies to employees. It does not apply to independent contractors. So let's look at the Employment Standards Act in a little bit more detail. So if we have an employee whose employment has been terminated without cause, there are two main entitlements that the employee would have upon termination. The first is called termination pay, which is, generally speaking, 1 week per year of service, up to a maximum of 8 weeks. And then there's another possible entitlement called severance pay, which is an additional 1 week per year of service, this time up to a maximum of 26 weeks. Now, in order for the entitlement to severance pay to apply, the employee must have at least 5 years of service with the employer, and one of the following two conditions must be met. Either the severance was due to the discontinuance of all or part of the employer's business, and over 50 employees were terminated, or the employer has an annual payroll of at least $2.5 million. Now, the case law has clarified that we're not just looking at a payroll of $2.5 million in Ontario. So if you're an employer who operates in other provinces, or perhaps even other countries, then you do have to look at the company's overall payroll. Employees are also entitled for their benefits to continue throughout the notice period if they're terminated without cause. So we're talking here about benefits like health and dental, RSP matching. For any American employers here, an RSP is essentially the Canadian equivalent to a 401k, and other fringe benefits such as car allowances, the value of shares, and stock options. Now, there are some little nuances that pertain to each of these types of benefits, but generally speaking, if the employee's employment was terminated without cause and the employee would have received the benefit but for the termination, then they are entitled to that benefit throughout the notice period. And this is the same thing with bonuses. So there was a relatively recent decision. It's called Paquette and Tarago Networks. It's a 2016 Ontario Court of Appeal decision. And essentially what that case says is that unless there is very clear language in the employee's contract, or presumably in a bonus policy that was also clearly drafted and was brought to the employee's attention, making it very clear that in the event of a termination without cause, the employee would not be entitled to any payment in lieu of bonus. If that condition is not met, then there is going to be liability for the bonus. All right? One issue that comes up constantly in employment law, in particular in the province of Ontario, relates to termination clauses. Okay, so we see many cases where we're dealing with termination clauses in contracts that aren't ultimately enforceable. Okay, so as we heard before, an employer is allowed to have a termination clause which limits an employee's entitlement upon termination. Okay, but the termination clause must provide for an equal right or benefit to the employee's ESA entitlements, and if not, the clause will be enforceable. So again, you cannot contract out of the Employment Standards Act. Okay, and the case law has now made it clear that because employees are entitled to benefit continuation under the ESA, if you draft a termination clause which lists other benefits that the employee would be entitled to upon termination for cause, but you don't include benefits, that's going to be enough to invalidate the clause. And in one of these cases, the court actually dealt with a situation where an employer said, okay, well, maybe the drafting wasn't perfect, but my intention was always to provide the employee with benefits, and look, we gave him a termination letter and we told the employee that the benefits were going to be continued. But the court said that no, that's not good enough. If the clause was not properly drafted, then you're stuck with that, and just because you complied with the minimum standards later is not going to be enough to save you. So we've come up with the following termination clause. So if your purpose as an employer is to limit the employee's entitlement upon termination without cause to the statutory minimums, we've come up with the clause here that you see on the slide. There have been a lot of cases that go all over the place, so there's never going to be any absolute certainty on this issue, at least in the near future. But that being said, we are fairly confident that this clause will hold up. Okay? Now, to be clear on what the consequences are of unenforceable termination clause, in summary, you're looking at paying out a lot more money as an employer. Because under the Employment Standards Act, you're looking at about 1 week per year of service for termination pay, and then, if applicable, another week per year of service for severance pay. At common law, there's also some uncertainty there, but a general rule is that the starting point for common law reasonable notice will be about 1 month per year. So already you're seeing that the entitlement in common law is significantly greater. So when the courts are looking at determining the common law notice period, they look at 4 factors that have been fairly well established. They look at the character of employment, they look at the employee's length of service, they look at the age of the employee, and they look at the availability of similar employment, having regard to the experience, training, and qualifications of the employee. And they use those factors to determine what the common law reasonable notice should be. Now, over the years, the way the case law developed, there was never any official cap. There was a fairly strong suggestion that 24 months of common law notice was the cap. Now, I would say that it's still rare for a court to award more than 24 months, but over time that may be changing. So I have here on the slide, there's 5 cases which are examples of the cases where the courts have awarded more than 24 months, or at least in one of them have commented that we don't really see that a cap should be appropriate. Now, perhaps the most significant one is the first one, and that's called Daw and Equitable Life Insurance Company. This is a 2018 case in which not only did the court award a 30-month notice period to an employee whose employment was terminated without cause, the court went even farther and said, and by the way, if the employee had requested 36 months, the court would have granted that. Okay? Now, in this case, we had an employee who was in her 60s. She had a very high managerial position, and there were simply put no other jobs for this employee after her termination. So the court's reasoning was basically that by terminating the employee and not letting her retire on her own accord, was that because the employer had essentially forced this employee into retirement, that a longer notice period was warranted. And again, this court would have awarded up to 36 months. So now we're looking at 3 years versus 2 years. So it's a significant increase. Okay? So what have we seen here? When we're talking about severance package, there's a lot going on here. There's a lot of considerations for employers to look at. So to make this a little bit easier, we suggest that employers speak to an employment lawyer at all times in the employment relationship. So in the hiring stage, very important to have a proper contract in place. Throughout the employment contract, maybe an issue has come up with respect to employee misconduct, an issue about vacation pay or time off or whatnot. employment lawyers can help you with that too. And finally, when you're dealing with terminations, it's a good idea to give an employment lawyer a quick call to determine, first of all, whether you may have just cause as an employer for the termination if the employee has engaged in misconduct, or if not, what sort of severance package this employee would be entitled to. Thanks very much. That concludes my presentation. I'll be here to answer any questions that you may have. And Larry's going to come back and wrap things up for us. Thank you.